Welcome to another episode in the Law Rapport. I hope you learned something from today's episode. So let's get right into it.
Welcome to episode 86 on the Law Rapport. In today's episode, I'm going to deal with the decision from the Court of Appeal in certifying 4 questions referred to it by the Attorney General of the Turks and Caicos Islands in relation to sentencing and exceptional circumstances in firearm related offences. This decision was handed down on the 29th of February 2024. The arguments were heard on the 16th of January 2024. I'll be back shortly to discuss this decision. But before I do, my usual disclaimer: this is not legal advice, should not be construed as such. For legal advice, please contact an attorney of your choice. Welcome back. Viewers of this channel may remember that in episode 67, I dealt with the issue of exceptional circumstances in firearms related offenses and sentencing, where I pointed out that local residents were concerned that only tourists or visitors to the Turks and Caicos Islands were being granted exceptional circumstances, and that they felt it was unfair and that the sentences imposed were unduly lenient. Well, the Attorney General, by virtue of the Attorney General reference of question, Ordinance referred 4 questions and the issue to the Court of Appeal for its certification or for its decision. And these questions dealt with Section 30 of the Firearm Offences Ordinance in relation to exceptional circumstances, and Section 3 of the said ordinance in relation to sentence. The 5 cases that were referred to are the case of David O'Connor, Alex Guzman, Mikey Williams, Alex Keith Nash, and Michael Grimm. With the exception of Mikey Williams, the other 4 defendants are non-residents or visitors to the Turks and Caicos Islands, and 3 of them were fined, the court having determined that exceptional circumstances did exist. 1 was sentenced to 8 months, but he had already served that 8 months and remand, so he was sentenced to time served. Mikey Williams was given a suspended sentence. What the court held is that on the findings of exceptional circumstances, the court is not at large to pronounce sentence, meaning that the court doesn't have an unfettered discretion to impose any sentence it wishes. 2, it held that the court had no jurisdiction to impose a non-custodial sentence if it finds that exceptional circumstances exist. And 3, that any sentence that was non-custodial is unlawful. And 4, that the court had no desire to set any rules as to what constitute exceptional circumstances. So let's look at the questions referred to the court by the Attorney General for its certification. Question number 1, and you should listen carefully because the court answer these questions individually, which I will go through coming to the end of this episode. So question 1 was, what set of circumstances may be considered as exceptional under Section 30 of the Firearm Ordinance? 2 are the circumstances in the case of the 5 defendants previously mentioned, O'Connor, Guzman, Williams, Nash, and Grimm. Were those circumstances indeed exceptional? 3, where exceptional circumstances are properly found to exist, what sentence under Section 3, subsection 3 of the Firearm Ordinance is the court empowered to impose as proportionate to the exceptional circumstances found and consistent with the dominant purpose or intent of the legislature? And 4, were the sentences imposed in the cases of the 5 defendants, O'Connor, Guzman, Williams, Nash, and Grimm, lawful? And even if lawful, were they unduly lenient? In answering question 1, the court held that it should not fetter the discretion of the sentencing judge by setting out a set of circumstances which may be considered exceptional or capable of being exceptional under Section 30 of the Ordinance. The court held that instead, the judge should exercise his or her discretion in applying the tests in the case of Regina and Rehman and Wood of 2005 and have regard to the obiter of the judge in the cases of Regina and Marian and Regina and Kelly. Therefore, the tests for exceptional circumstances approved by the court is a set of particular and unusual circumstances that affect the offender or the offense, and in the opinion of the court, justify it in not performing its statutory duty of imposing the mandatory minimum sentence. The court continues. In informing that opinion, the court, which is the sentencing court, must have regard to the dominant purpose of Parliament in enacting Section 3 of the Firearm Ordinance. In answer to question 2, referred by the Attorney General, the court held that with the exception of the defendant Williams and the facts presented and the authorities before it, it cannot say that the judges were clearly wrong in forming the opinion that there were exceptional circumstances. In answer to question 3, the court held that where exceptional circumstances exist, the court has no jurisdiction to impose a non-custodial sentence. In answer to question 4, the final question, the court held that the non-custodial sentences imposed were unlawful and therefore unduly lenient, and the custodial sentence imposed on the defendant Mikey Williams was unduly lenient because the findings of exceptional circumstances in that case was clearly wrong. But the court went even further and held that the 3 years suspended sentence imposed on Williams was unlawful as it contravened the suspended sentence ordinance. Under the suspended sentence ordinance, the sentence can only be suspended if it is not more than 2 years. And as Williams' sentence was 3 years suspended for 2 years, it was more than the 2-year sentence allowed under the ordinance, and thus it was unlawful. However, in my view, a larger question looms. The Court of Appeal was very reluctant in fettering the sentencing court in setting out a set of circumstances that would constitute exceptional circumstances. But on the other hand, notwithstanding Section 3 of the Firearms Ordinance, the court went on to pronounce very strongly and definitively that once the sentencing court finds exceptional circumstances exist, it has no discretion to impose a non-custodial sentence, thus, in my view, fettering or tying the hands of the sentencing court. I believe that this raises, in my view, a constitutional question that needs to be settled, and probably this question may have to be settled by the Privy Council, our final Court of Appeal, because I'm of the view that there's an arguable case that the judge, having found exceptional circumstances, should be at large to pass any sentence within the spirit and the letter of Section 3 of the Firearm Ordinance. This matter may still have some life. It will depend on if the authorities for the interested parties decide to take this all the way to the Supreme Court. Here is where I will leave this episode for today. If you learned anything from this episode, if you enjoy, please like and share. Please give it a thumbs up. Most of all, I thank you for taking time out to look at this episode. Cheers. See you in my next episode.